to promote research and debate in the fields of commercial laws. Over the years, it has witnessed participation from students, legal academicians, and professionals. The journal has been ranked amongst the top 10 most accessed law journals by SEC. We are fortunate to have Mr. Pratika Shankar with us today, and we are grateful that he agreed to be the resource person for the workshop. Mr. Shankar is an alumnus of Rajiv Gandhi National University of Law. He is the managing associate at Talwar Thakore Associates, which is one of the most esteemed law firms in the country. He has more than 8 years of experience working with various national and multinational corporations and holds expertise in the field of inbound and outbound strategic mergers and acquisitions, private equity, and structured financing. We are immensely grateful to Mr. Shankar for taking out his valuable time to conduct this workshop. We are also grateful to our Editor-in-Chief, Professor Dr. Anand Pawar, for providing us with an opportunity to organize this workshop. As our faculty editor, Sir has always supported us, and no event would be possible without his constant support. The workshop is on the topic of mergers and acquisition, which holds great importance in the field of corporate laws. The workshop shall elucidate extensively on M&A transactions and is tailored to provide practical insights into this important subject. Since we desire to make this an interactive session, everyone present here is encouraged to send all their questions and queries privately to the Q&A ID present in the chat box. I would now request Mr. Shankar to take the floor and start the workshop.
With some settings, I guess. Anyway, thank you very much, Srishti, for the kind introduction. Good morning, everyone. And I think before we begin, wish you all a very happy new year and hope everyone is keeping safe in this whole pandemic kind of situation, as unfortunate as it may be. I am also unfortunately COVID positive as I speak, but thankfully it's all going good, and hope everyone else is going to be safe as well. So I think this is interestingly the second of second workshop on what I would now like to call the demystifying series of workshops, because I think the last time I did this with RFMLR was on demystifying the due diligence universe, and I think this time we have demystifying M&A transactions. I think both of them are interlinked, but I think also apart in terms of how you process these transactions, in terms of how you structure the transactions. Due diligence is only a part of an overall M&A transaction, and the M&A transaction could include 5 to 6 things, including structuring, diligence, documentation, etc. And the diligence was only one part of it. But I think last time we did this was because apparently lots of students, especially and junior associates, were very confused about the relevance of due diligence in a law firm and how it's important in the context of a transaction. People would face a lot of issues when they intern. They are dumped with a lot of documents to review and summarize. So I think that kind of session was helpful to understand the actual practical relevance of due diligence mandates. I think here we are, series number 2. So first we dealt with the subset. Now we are looking at the universe itself. So we are at demystifying M&A transactions, exploring the nuances beyond theory. Should we begin, Srishti? Can we go to the first slide, please? Okay, all right. Achha, I just want to understand, I want to make this as interactive as possible. Srishti, are people allowed to speak, as in, or are they able to unmute themselves, or is there any way by which they can raise their hands if they have a question?
So for questions, we have a question and answer chat, an option of question and answer in the chat box. So all the attendees can send their questions in the chat box, and then we can present those questions to you so that you could answer them and clarify their doubts.
Okay, lovely. Sure. Okay, so let's begin. So before delving into the technicalities of it, and I think because the topic itself says exploring the nuances beyond theory, I think it's first very important to understand the theory and at least understand what these words mean. Now, as you will see, Typically, when someone says M&A, you would think that it means mergers and amalgamations, you know, but actually M&A doesn't mean mergers and amalgamations. It means mergers and acquisitions. And therefore, if you see the M here actually stands for mergers and amalgamations and the A stands for acquisitions. Now, what is a merger? A merger is a combination of two or more entities. Typically, one entity would merge into the another entity. So if company A and company B are merging with each other, there are quite a few possible outcomes of this merger, but typically it would involve one entity being subsumed into the other entity. So A plus B could result in A, or in certain situations, A and B would combine together and they would form a different entity C, in which case entity A and B will both lose their existence. Now, what happens is all the assets and liabilities of one entity which is merging into the other entity get transferred into the resulting entity. And this entity practically ceases to exist. All the shareholders of the merging entity will get some shares in the new entity or the resulting entity. That's how a merger kind of works. As the name suggests, it's a merger, it's a combination, and also it's an amalgam of a kind, you know. So amalgamations are and mergers are concepts that are not typically are not actually defined in the Companies Act, but there are processes that are set out in the Companies Act. Both of them are code driven processes. We'll go to that when we discuss corporate reorganizations as part of M&A transactions. But for now, what is important to understand is that when we say M&A in the common parlance, the M stands for mergers and amalgamations. Mergers and amalgamations are processes through which two or more entities combine to form a third entity, or one entity subsumes itself into the other entity and loses its existence as a corporate entity. Now, what would be the kind of mergers? The kind of mergers could include horizontal mergers, vertical merger, congeneric merger, conglomerate merger, and market extension. Now, horizontal merger is in the market. Like if, for example, two telecommunication companies for Idea or Vodafone. I mean, the most recent example of a merger is this new entity called VI, right, which is Vodafone Idea India. So Idea was a different mobile phone company. Vodafone was also an independent telecom company. The two of them merged. I mean, when we say merged, one of them could have acquired the other as well, but of course, it was like a scheme of merger. So Vodafone and Idea combined to become VI, which is Vodafone Idea. So this is an example of a horizontal merger where technically the two merging entities are competitors, but they decide to come together, merge into a new entity, and one of the entities loses its existence. Here, actually, Idea has kind of lost its existence, and the resulting entity VI is basically a Vodafone entity. Now, vertical mergers, again, these names are self-explanatory. Vertical merger is where you are in a different where the entities merging with each other are in different stages of the process. Like if I'm so you wear rubber shoes, right? So where does the process start? The process starts at extraction of rubber from the trees. So there would be one company which is engaged in that business. Then there will be one company which is engaged in the business of processing uh, rubber out of natural rubber. And the third entity maybe would be a wholesaler of that rubber, making sheets. And lastly, the last entity that retails it to you would be making shoes. Like, for example, the Batas and the Liberty, all these shoe companies. Now, what if an entity which is engaged in the business of extraction of rubber, for example, or let's take a more realistic example, in the business of processing synthetic rubber, processing rubber out of the natural rubber, decides to also engage in the business of making rubber shoes, you know. So then what it will do is it will identify a target entity like Bata, for example, which is already engaged in that business, and it will want to merge itself. Now, what it does is for a company which is at the back of the process chain, and it acquires an entity which is kind of manufacturing and retailing an actual product, it kind of gives you a supply chain kind of advantage, because you are integrating your processes such that there are synergies, because you don't have to rely on your consumer, which is actually not itself a consumer, it is another wholesaler in the chain. You eliminate those processes, so basically you only have two people in the chain, one entity that extracts the rubber, and then after that you can take over the entire process after that and just basically work with the end consumer. So I may want that kind of a merger as well. So that is called a vertical merger. Similarly, there are other forms of mergers. I think it's a topic of a different workshop to go into the details of all sorts of mergers. Market extension, for example, would mean where I'm performing the same function but in a different geographical market. And I may be a rubber manufacturer in Brazil, but if I want to expand my footprints into India, I may want to acquire an entity, or I may want to merge with an entity that is doing exactly the same business but in India. So that's like a market extension. So there are various kinds of mergers. This is not a legal concept as such. These are all commercial concepts devised by the fancy MBA MBA folks. From our perspective as lawyers, we are only concerned about the legal implications and the legal considerations of these sort of mergers. And just to let you know, no matter what type of a merger it is, the legal processes will remain the same. The legal considerations and the documentation involved will also remain the same. Now let's come to A. A is acquisitions. Now again, as the name suggests, it is the process where a person or an entity acquires full or part ownership of another entity or purchases the business of that entity. So mergers and amalgamations, this might be a little confusing at the face of it, because even in a merger, one entity is acquiring the other, but the difference is that an acquisition is actually, common parlance, we use terms like takeovers, buyouts. So when a company takes over another company, where a company buys the shares of another company, it is called an acquisition. Where a company acquires the business of another company, this company is acquiring the business. It's not merging. When the companies merge, their rights, assets, liabilities, litigation, employees, kind of everything merges together in one scheme. It's called the scheme of merger or a scheme of arrangement, where everything merges and the court approves that kind of combination and there is a new resulting entity. It's kind of, it's a very inorganic kind of a process, where an organic process will be company A buying company B, and then company B being owned by company A after this transaction closes. But a merger is inorganic because company A does not buy company B. Company B says, you have XYZ liabilities, I have ABC liabilities, we'll combine the two. We have the following assets. You have different sets of assets, I have different sets of assets, we will combine our assets. We will combine our employees. We will combine all of our synergies, all of our contracts. And then the resulting entity effectively takes over the entire business of company A and company B. That resulting entity could be called A, it could be called B, or it could also be called C. But that is essentially the difference. Like the banks merger, you would have heard, for example, the Andhra Bank merged into the Union Bank. So Union Bank did not acquire a control in Andhra Bank. Union Bank did not acquire shares of Andhra Bank. If that were to be the case, then Andhra Bank would have continued to exist. But it does not. Andhra Bank has now become Union Bank. So that is how and all the customers of Andhra Bank are also now Union Bank of India customers. So that's what you need to keep in mind when you want to differentiate between a merger and an acquisition. In a merger, one entity would completely lose its existence, or both the entities lose their existence and become a third entity. In an acquisition, one entity acquires ownership interest. It could be a minority ownership interest, it could be a majority interest, it could be an interest of the entire share capital or the entire ownership. But effectively, what is important is there is some ownership. In certain situations of acquisitions, we in fact consider businesses or assets of the company as also being part of acquisitions. When you acquire the business of a company and not actually the shares of that company. So this is a broad conceptual overview of what M&A means. I mean, I'll kind of give you 10 seconds if you have any questions. I think I just got a message as well. Everyone is requested to send their questions and doubts through the Q&A option in the chat box. Please do let me know if you want to understand anything or if something is unclear.
So, sir, we do have some questions. So, first question is from Miss Ananya Bhardwaj. She's asking, what is the difference between the term merger and amalgamation?
Nothing, actually. I think we'll come to that in a bit. But effectively, mergers and amalgamations are kind of, I would say, Income Tax Act beasts, because the Companies Act neither defines a merger nor it defines an amalgamation. A merger is actually defined in the Income Tax Act. So there's no distinction, if you ask me legally, no distinction between mergers and amalgamations. I think I have one more question. Is it true that merger will always result in the formation of a new entity? I think I just answered that question, saying that it is not necessary. It could be A plus B is equal to A, and it could equally be A plus B is equal to C. You know, like classic examples, Union Bank merged with Andhra Bank, and the resulting entity is called Union Bank. Yeah. I hope that is clear. Please let me know if it's not.
So we have another question. This by Miss Anvesha Chaturvedi. She asked, if the government purchases the shares of VI, is it an example of an acquisition?
It's always an acquisition, no matter who the purchaser is. The purchaser could be the government, the purchaser could be a private individual, purchaser could be an entity. It will still continue to be called an acquisition. It won't become a merger. And I think as far as mergers and amalgamations is concerned, I think the best way to tell you why these two are not distinguishable in a way is because if you look at the Income Tax Act, it actually defines an amalgamation as a merger of two or more entities with another entity. So, these are interchangeable kind of words.
The
Should we
next
move
question,
on?
just
Okay.
one question. And the
Yeah,
next
please
question
go ahead.
is, what is the exact meaning or interpretation of purchasing the business of such entity?
Yeah, so the interpretation of purchasing the business is a totally is basically two slides which I'm going to cover later on in the presentation. But just to give you a very brief answer, if you acquire the shares of another entity, it's a share acquisition. If you buy the business of that entity, if the entity, again using the rubber example, if the entity is engaged in the business of manufacturing rubber products, and what I want to do is maybe buy the factory, all the employees that are engaged in that factory, and the plant and machinery in that factory, it's called a business acquisition without actually buying shares of that entity. I hope that is clear. Yeah. So we'll move on. I think some of these questions will get answered as we go along. If they don't, then I think at the end we'll have a 15-20 minutes questionnaire kind of question and answers interactive session, and I think it'll be clear then. So we'll move on. Now we understand what mergers, amalgamations, acquisitions mean. Now let's try and understand the steps involved in M&A transactions. And I think this is where we come to the second part of that brief description of this workshop, where you say the role of lawyers in M&A transactions. I think what we discussed until now was an introduction to the M&A. Now we come to the meat of how an M&A transaction is done and what role lawyers play in these kind of transactions. So the steps involved in an M&A transaction are the first and most important step, without which any M&A transaction is going to be incomplete, is commercial discussions on the deal structure. Now, if I want to buy out shares of a company, if I want to buy the business of a company, the most important thing that I need to do is to have a discussion with that company's management, right? I mean, I'll discuss with the promoters, I'll discuss with management, the broad contours on which that deal has to be structured, and how the structure is going to be implemented, etc. Whether it's going to be a share purchase, a business purchase, or or an asset purchase, which is another different type of acquisition. The only exception to this that may be crossing your minds is what happens if it's if it's a hostile takeover, where one entity does not actually have any discussion with the other entity, and you just just basically buy the shares of that entity of the stock exchange, for example. So that is possible, but typically our M&A transactions do not involve uh, sort of these kind of hostile sort of takeovers, because they are in the domain of public M&A transactions, and there's a whole lot of SEBI related regulations, etc., that become applicable to you. You have to make an open offer, etc. So we'll not go into that many details about a hostile takeover. But simply understood, the first step is the parties discuss amongst themselves the structure of the transaction. And typically, if you ask me, lawyers are not involved in this stage of the transaction. And this stage, it's only the commercial parties to the transaction which discuss the deal structure. And typically, they would also execute, which is set out in number 2. They would also execute a commitment letter. I mean, this commitment letter could could have various names. You would have heard the words letter of intent, memorandum of understanding, binding or non-binding, term sheet, etc. All of these terms effectively mean the same thing. They are essentially a kind of commitment that is made by the parties, saying that we will enter into this transaction on the following broad commercials. So typically these term sheets and MOUs do not contain the entire sort of framework of the transaction. They don't set out every detail about, for example, representations, warranties, closing actions, etc. All they set out is what the transaction is going to be and how it's going to be implemented. And I think this is the piece of document, this commitment letter or the term sheet is the piece of paper that the lawyers typically get in the first place, based on which they would start working on the transaction. So typically, I would say in 8 out of 10 transactions, the involvement of lawyers begins with the commitment letter or the term sheet. Uh, uh, we are provided with this kind of document, and then looking at this document, we we figure out what the transaction is going to be and how it needs to be implemented. Now, the third important part of an M&A transaction is the due diligence of the target, about which I have already done a full sort of workshop. And due diligence is of various kinds. It could be a legal due diligence, it could be a financial due diligence. In a financial due diligence, of course, as the name suggests, you look at the numbers, you look at the finances, you look at whether the business value that is being quoted by the promoter is actually the value of the business, or is it higher or lower. There could be tax due diligence, trying to figure out whether there are no pending tax proceedings, tax assessments. There are technical diligences, especially where you want to acquire a manufacturing business, for example. You would want to see whether that business is being performed properly using the correct machinery, whether the business is properly compliant with all the technical requirements. If the company says that, our unique selling proposition is that we have a patent over a particular sort of product that we have built, you would want to see whether the patent actually exists or not. Yeah. So these are parts of technical due diligence. Then there's other kinds of due diligence as well, like EHS, where you look at environment, health, and safety. You see whether the business is polluting the environment. You see what the businesses are doing to ensure health and safety of its employees, and so on and so forth. So I think, looking at it stepwise, I discussed with my partner, we want to get into a business transaction. Uh, I'm not really interested in buying your shares, but I'm actually interested in buying your entire production business, you know, along with your plant and machinery, factory employees, etc. Why don't we enter into a term sheet? We say that these are the parties, party A, party B. This is the nature of transaction. Party A intends to buy the business of party A's whatever production facility, etc. Expected closing date is, say, 3 months from now, 6 months from now. Steps involved would be finishing due diligence, etc., entering into transaction documents which are appropriate, appointment of counsels, and then typically term sheets would have this confidentiality and binding confidentiality and sort of exclusivity terms saying that because I am in discussions with you about this transaction, I don't want you to basically shop with other entities in the market and try to look for similar transactions, because then it's a waste of my money and resource with you, right? So there's an exclusivity kind of commitment for a limited period of say 3 months, 6 months, wherein you will not go shopping to other potential sort of buyers or sellers. And then there's of course non-disclosure commitment saying that whatever we've discussed and whatever we will discuss as part of this transaction until the date the transaction documents are signed will all remain confidential, because the transaction documents will then anyway have detailed confidentiality obligations. So then those obligations kind of replace the obligations that you've agreed in the term sheet. So this is how a term sheet is typically structured. It's that piece of paper that gives you the soft comfort that this transaction is going to happen. Of course, subject to various other uh, permutations and combinations getting met. And then the lawyers are given this piece of paper. On that basis, we start our diligence exercise. We are generally very focused on the legal due diligence side of things. The other ones are handled by other experts like tax, finance, technical, etc. The next one is execution of transaction documents. Now, this is a very important part of what lawyers do in addition to due diligence. We prepare the transaction documents depending on the structure of the transaction. If the transaction is a share purchase transaction, then we would prepare a share purchase agreement. If the transaction has to be structured by way of one entity issuing shares to the investor, then we have a subscription agreement. Similarly, if we are only buying out the business, then it's a business purchase, asset purchase, and this is the document that basically sets out the legal rights and obligations of both the parties in relation to the transaction. It sets out the consideration amount that has to be paid, the value that has to be paid for that acquisition. It sets out all the conditions that need to be fulfilled, which is number 5 in this list, fulfillment of all the conditions precedent. It sets out all conditions that need to be fulfilled. It sets out what happens exactly on the date on which the transaction completes, which is called closing. Payment of money, transfer of shares, or transfer of papers relating to the business, etc. And it also sets out post-closing obligations, like there are certain regulatory filings to the ROC, etc., government, which businesses will have to make when they are acquired by another business or when they acquire other businesses. So all of these things are kind of set out in the transaction document. In addition to the transaction document, also set out representations and warranties of each party. Now, representations and warranties are essentially the backbone of any M&A transaction. So any party to a transaction will enter into a transaction with the other party on the basis of certain statements of fact made by the other party. Saying I am a company duly incorporated in India. Okay. So if you are not a company duly incorporated in India, I can't do this transaction with you. For example, if you're a sole proprietorship, I don't want to enter into a business with a sole proprietorship. Okay. So why don't you give me a representation and a warranty saying that I am a company duly incorporated in India? You say I have only 2 shareholders, and I want to buy out your entire stake, 100%. So how am I going to be 100% sure that you don't have a third shareholder? I can obviously go and due diligence the company if there is a due diligence. Mind you, number 3 is not applicable for every possible transaction that we do. Very, very limited types of transactions will have a full due diligence kind of exercise. In certain situations, clients don't prefer to do due diligence. They'll be like, okay, it's a minority stake. I'll just go ahead and acquire. Generally, for minority transactions, 2%, 3%, 5%, you would it's less often to see a full diligence exercise. For control or majority deals, it's more often that you will see diligence exercise. But even diligence exercises cannot be relied on completely, because whatever you diligence is based on the information provided to you by the company. So if the company has supplied false information to you, you will still need to make a claim against that company for providing false information or incorrect information. But what happens if that incorrect information or representation provided, incorrect information provided that you were in a situation where the government imposes a penalty on you, or for example, the government says that you were never entitled to hold these shares, but you have still held these shares, so we will take action against your business. In that kind of a situation, you are left with no recourse. In order to create that recourse, we have the concept of representations and warranties. You have to tell me everything about your business that I want to know. And all of these statements of facts will need to be recorded as a warranty. If you breach any of that, or if it turns out tomorrow that you have misrepresented to me any fact or event that relates to your business or relates to your legal ownership of the shares of the business, of the plant and machinery, assets, any pending litigation, etc., against you, I should be able to make a claim against you for that. Yeah. So these are all things that are set out in a share purchase agreement or a transaction document in a way. Then obviously confidentiality obligations, dispute resolution, notices, and the like. Then, of course, number 5 we discussed. There are certain commercial conditions precedent, which could basically be that as part of my diligence, I figured that the target entity has availed of a loan from a bank, and that the loan documents provide that the target entity cannot enter into any kind of transaction which allows its change of control, for example, or any transaction which allows its ownership pattern to change without the prior approval of the bank. So in that situation, the transaction document will set out, based on the diligence exercise. In the transaction document, you will set out a CP saying consent of the bank to be obtained in relation to this transaction as a condition precedent. So those kind of condition precedents are called commercial CPs. Then the other category of CPs could be regulatory approvals. Now, of course, there are various kinds of transactions in India which require approval from the government. Like, you must have heard of the term foreign direct investment. So in India, there's a consolidated FDI policy. There are FEMA non-debt instrument rules 2019. They set out certain in those sectors which require prior approval of the government. So if your sort of sector of investment falls into one of those approval routes, for example, then you will require government approval. So while you can still enter into the transaction document, you will put out a condition in the document saying approval of the government of India or approval of the RBI having been obtained in relation to the transaction will be a specific CP that you will have. I hope that is clear. Of course, if there are questions, please write and I'll be happy to answer. Then closing is the process through which the actual transaction takes place. If it's a share acquisition, then closing means the date on which the shares are actually allotted, or the date on which the shares actually stand transferred from one account to the other. This is called closing. There are various actions that take place on the closing date, all of which are set out in the closing schedule. And of course, post-closing, I mentioned to you that there could be ROC filings, certain approvals that are not readily forthcoming, and the investor is like, okay, I need to buy this company as soon as possible. What I'm okay to do is to defer some of those conditions as a subsequent rather than a precedent. I want you to get a particular license for your business because I think it's important for you to get it. Although you've taken the view that you don't need that license, what I will do is, you tell me that it's a time consuming process to get that license. What I will tell you to do is, let's go ahead, let me buy this business. I don't think I will be unable to run the business without that license. So I'm willing to take that commercial call where I get the business without that license, but I give you 30 days from the date of completion to get that license done for me. Yeah. So that could be a condition subsequent that needs to be implemented after the closing of the transaction. So these are the steps involved in an M&A transaction. Please do let me know if you have any questions. If not, then we will move ahead.
So we do have some questions. The first question is, do M&A lawyers engage only in transactional and advisory front, or do they also operate in the litigation front?
So I'm so sorry, Shrishti. I will be able to answer this question, but I don't think it's related to what we are discussing right now. So I think we can take this at the back end of the seminar, maybe. Any other questions?
Yes, sir. The next question is that in some disputes, such as the Oyo-Zostal dispute, term sheet was held to be non-binding, despite it being mentioned as a binding document at the beginning. How can parties deal with this practical problem?
So what happens is that even if you say the transaction, even if you say the term sheet is a binding piece of paper, uh, and you enter into a subsequent transaction document, like generally these kind of disputes where the term sheet is brought into discussion in a court of law is where there is a conflict between what is written in your binding term sheet versus what is written in your share purchase agreement or a share subscription agreement or any other investment document for that matter. So if you say one thing in the term sheet, if you say another in the actual transaction document, and if there's a dispute, one party is trying to show the term sheet to say that, this was agreed between us, and the other party says that, no, the term sheet is of course not binding on the parties because there is a subsequent binding document that has been executed between the parties. It is only in those kind of situations where the term sheets are discussed. If you take a situation where there was only a term sheet which says that this is a binding document and the companies will enter into the transaction on the basis of what is set out here, in a way that becomes a binding agreement, unless there is language in that term sheet suggesting that it is only a proposal. It's a binding proposal in the sense that parties are required to take relevant steps to ensure that this proposal takes effect. But if in the guise of a term sheet or if in the guise of an MOU, you are actually setting out every CP, you are setting out the closing mechanics, you are setting out the approvals required, the reps and warranties, etc., then it kind of becomes an agreement, right? It doesn't remain to be a term sheet. So again, just to simply answer the question, calling a term sheet as binding and then challenging whether it's binding in a court of law will actually depend on the facts of the case. There's no correct legal principle, there's no right or wrong here. There's no section of the Companies Act or any other contract act or the Contract Act which says that a term sheet becomes binding only if ABC conditions are met, right? So you will have to look at how the term sheet is drafted. You will have to look at the intent of the parties entering into the term sheet, and you will also have to look at whether the term sheet is followed by another transaction document like a share subscription agreement, share purchase agreement, investment agreement, which kind of supersedes the term sheet. So typically what we would do is, in a transaction document like an SPA, SSA, we have something called a whole agreement clause or an entire agreement clause. And that clause basically says that the parties are entering into this agreement in supersession, or this agreement supersedes all previous understanding documents, agreements, letters executed between the parties in relation to this transaction, which is a defined term. And this agreement is the only piece of paper that the parties will need to rely on to understand their rights and obligations in relation to this transaction. So if you have something like this, and then someone is claiming that the term sheet is binding over this kind of a document, then you look at the facts on that basis and the decision will be made accordingly. I think I've got another question, something related to term sheets only, right? Are specific clauses of term sheet binding, such as confidentiality and the non-disclosure? Yeah, of course. I mean, we've also dealt with situations where we build in, where we say that the term sheet is not, it's a non-binding term sheet, for example, but your confidentiality and non-disclosure clauses are binding. So of course, you can't go and basically shop with other entities. So that's also possible. Yeah, the answer to that question is yes. And to make it abundantly clear, we have actually done this where the parties have preferred us to do that, where when we draft term sheets for them, we say that except clauses X and Y, all the other parts of this term sheet are non-binding in nature, and those clauses X and Y are confidentiality and non-disclosure clauses. I hope that answers the question.
The next question which we have is
So should we move ahead now?
So the last question which we have is what is the
Srishti, we have other questions as well.
Yes, sir. Just one last question. This is what is the difference
Sorry,
between
am I the only one who cannot hear you properly? I think you're breaking.
Am I still breaking, sir? Is my voice now audible?
You're breaking up, yeah. Can you try again?
Sir, is it now audible?
Yeah.
So, sir, the question is, the question is, what is the difference between a share purchase agreement and a share subscription agreement?
Srishti?
So am I audible to you now?
Yeah, now you're audible. I couldn't hear you before.
Yes, sir. So the last question is, what is the difference between a share subscription agreement and a share purchase agreement?
I'll come to that. It's the next part of the discussion. Okay, so should we move on? Yeah. Now, forms of M&A transactions, share acquisitions. So there you go, whoever has asked that question. So as I told you, there are various forms of M&A transactions, one of which is acquisition of shares. And when I say acquisition, I'm categorizing this under the broad head of basically subscribing to new shares of the company and purchasing existing shares held by a different shareholder of the company. So typically, share acquisition transactions can be characterized or can be distinguished on the basis of various factors. And these factors could be one, based on the purpose of investment. Now, if I'm a private equity investor, I hope everyone is familiar with the term private equity or venture capital investor. But just for the uninformed, I'd basically summarize it in two sentences. So, a private equity investor is an investor which is engaged in the business of making money by making investments into entities, staying for a while, and then basically exiting. It's like you buy shares of certain entities on the stock market whose businesses you like, right?
I don't have to basically contract with a different. Sorry, can you guys not hear me?
You're audible now, sir.
Sorry, I think my Wi-Fi went off for like 10 seconds. What part uh, of it did not listen to, I guess?
So
Should I repeat myself?
I think this whole slide, you weren't audible.
Okay, okay. Oh shit, that's too bad. Okay, so we were saying the first type of M&A transaction, the first is based on the purpose of investment. Now, purpose of investment would mean why the investment is being made. And as you see, the names here are private equity investments, strategic investments, and joint ventures. Now, private equity investments would basically mean, there are private equity investors, venture capital investors. I don't know if you've seen Shark Tank, for example. So there they say, there they show you what private equity investment or venture capital or seed funding kind of investment means. So it's basically structured in a way where there are pooled investment vehicles or someone who is sitting on a ton of cash and they want to deploy that cash for a short time period to make money out of that investment. It's just very simply the simplest analogy I can give you is when you buy shares of various companies on the stock market or the share market, you don't know about the business of those companies. You are not invested in any of those businesses. You are not, for example, if you buy shares of Maruti, you are not a car manufacturer, right? You are an investor sitting at home who has money to buy shares of the car company. So this is not typical private equity investment, but when you structure an investment in a way where there is to get into the company, leverage the company's growth in a short span of time, 2 years, 3 years, and then exit at a higher return. When the valuation of the company soars after a few years and you want to take your money out, sell out to whoever or the promoter, and then get out. That's a private equity investment. Strategic investments uh, are actual business decisions that are taken by an investor. If I am an entity which is engaged in, for example, the business of slippers, but I don't have any control over my raw material suppliers, for example. So what I would do is I might go and buy one of the entities that manufactures those raw materials. So that is a strategic investment. I have strategically invested in an entity that manufactures certain raw materials that I use in my business. If I buy that entity, then I'm sorted because I have synergies, I have a supply chain ready for me. That is a strategic investment. Joint ventures could, for example, mean that I'm bringing my own synergy into the business. You bring your own expertise into the business, and then we work together as a joint venture. Like, again, another example. If I am an entity which is, say, India's #1 trader of copper, copper anodes or copper cathodes, and I enter into a joint venture with another company which specializes in manufacturing copper wires, and we want to, for example, build a plant, and the plant will produce copper wires and various copper related products, then it's a joint venture. I bring my own expertise, you bring your own expertise, we work together and we create a product or we create a process, and that process generally gives financial returns, business returns to both the investors. Joint ventures are typically structured as 50-50 joint ventures, 51-49, 60-40. One entity could have control over the other, or maybe none of them have control over that entity, and it's always joint ownership and joint control. So this is based on the purpose of the investment. Then based on the resident status of the investor. Based on the resident status, it could be domestic transactions, where both the investor and investee company are Indian entities, or it could be a cross-border transaction. Cross-border transactions are also of two kinds. One would be where there is an inbound M&A. Inbound M&A means that you have an investor who is a non-resident who wants to invest in the shares held in the shares of an Indian company. It's called an inbound in M&A. But when the investor is sitting in India and it wants to buy shares of a company which is situated outside India, it's called an outbound M&A. So inbound M&A and outbound M&A. Now, inbound M&A, classic examples are foreign direct investments, including downstream investments, foreign portfolio investments, and other foreign investments, where you basically buy shares of an LLP, you buy shares of an investment vehicle, etc., etc. I mean, these are all kind of very technical. We'll not go into the technicalities of foreign investments in India. But I think for the purposes of this discussion, it's important to understand that where an investor situated outside India is buying shares or a business which is located or situated in India or incorporated in India, it's an inbound M&A. When the investor is in India, the business is situated outside India, it's an outbound M&A. I hope that is clear. Shrishti, are you all able to see me? Is my video on?
Yes, sir, you're perfectly visible.
Okay, great. Because I'm having some trouble with my internet connectivity, but I just hope it doesn't completely die. Okay, so are there any questions on? Okay, let me finish this. I think the second part is also linked to the forms of share, the reasons for doing share acquisitions. Can we move on? Yeah, so based on constitution of the target company. No, let's go one slide back, Shrishti. Yeah, based on the constitution of the target company, private M&A, public M&A. So private M&A, typically, this is not a legal term, first of all, and I think the most you will hear about these terms is when you try to understand the practice areas of firms, and you say, which team are you in? So you say, I'm in the public M&A space, or I'm in the private M&A space. So that typically you would hear these words, but what it effectively means is any investment into a private limited company or a public unlisted company, which is governed only by the Companies Act, is typically in common parlance known as a private M&A. But an investment into a public listed company, which has additional compliances from a SEBI perspective, in addition to the Companies Act, is typically the public M&A space. And if you go to UK, I mean, if you look at the firms and the practice areas there, I think this concept of equity capital markets that we have in India, where you do IPO related work, etc. Even the equity capital market or ECM work, what we call in India, is also categorized in the public M&A sort of bracket outside India. But in India, ECM is typically considered to be a different practice area. And private M&A is kind of slightly different, which is only dealing with Companies Act related compliances. The next is based on the mode of investment. Mode of investment, of course, and I think this relates to one of the questions that I got. There could be primary issuance, where you are issuing fresh equity shares, compulsorily convertible preference shares, compulsorily convertible debentures. You know, equity and equity linked instruments is how we like to call it. And now the regulations are also worded. So when the company issues fresh shares, you know, these, you are not buying anything from anyone, you are buying the company from the company itself. You know, how does that work? If the company presently has two shareholders, each of them have 50% shareholding, you want to come in as the third shareholder of the company, but none of the other two shareholders want to sell their shares to you. They want to hold on to their shares, and the company wants to still, or they're saying, we will hold on to our shares, why don't you subscribe to new shares? Then what the company does is the company issues new shares to you as the third shareholder, and the process is called a private placement. If you've read the Companies Act, section 42 of the Companies Act deals with private placement, and section 62 1C of the Companies Act talks about preferential allotment. So typically, preferential allotment by way of private placement is how you would get in a new shareholder into the company without actually having the other existing shareholders transfer their share. The end result is the same. The existing shareholders will get diluted as a result of this transaction. But how they get diluted is not by way of acquiring shares of an existing shareholder. It will be by way of subscribing to the new shares of the company. And then, of course, the second is secondary acquisition. Secondary acquisition is anything which is not a primary issuance. You buy shares from an existing shareholder of the company. And the next is based on the ownership percentage. I think this also we briefly touched upon. It could be a minority acquisition where you are buying, say the key thresholds here are 10%, 25%, 10% and 25%. Why 25%? What I'll do is I'll not answer this question. Let's see if people can answer this. If people can answer this question on the chat box. Why a 25% threshold is important? Similarly, when I do a controlling acquisition, why would you think that a 75% shareholding is an important threshold? Let's see what answers we get. But to briefly summarize this point, investments could be minority stake, it could be 50-50 joint ventures, or it could be controlling acquisitions. Shrishti, if we don't get an answer to this question, please remind me towards the end. We'll discuss this. Okay, because listed companies need to keep 25% for stock exchanges. No. So my question is, when I'm doing a minority acquisition, and you are factually right, legally right, but the question is, when I do a minority acquisition of the company, why is the threshold of 25% important to me? Let's assume it's a private company. It triggers an open offer beyond 25%. Okay, yes. But what if it's a private company? Okay, let's see. Gracie Vindra says voting rights are affected. Okay, so we've got some answers. Why don't we finish this thought process? Okay, I think I've just got the answer. Just popped up on my phone. It's not appearing in the chat box. Someone said about a special resolution, Shrishti. Did you get that comment anywhere? It just popped up on my phone, but I can't see here. I think someone said something about a special resolution.
We have a comment about SEBI SAST 2011 regulation.
That I saw. I just saw one comment from someone which said special resolution. Yeah, Vedangshi. Special majority is at 75%. So if one person acquires more than this, then it's not minority. Okay, let me rephrase that answer. The thought process is correct. So the threshold of 25% is critical because there are various actions, including a Section 42 resolution for private placement, which requires a special resolution by the members of the company. Now, a special resolution has to be by way of at least 75% of the company's shareholding, or in certain cases, it's 2/3 of the majority of the people who are present and voting. So then that 25% threshold kind of becomes 33% threshold. But typically, the way this works is the way the transactions are all, the way the documents are generally drafted. There are certain regulatory decisions which cannot be taken without a special resolution. But there are certain commercial decisions that the parties decide we will not take without taking approval of a certain minimum number of percentage shareholders of the company. And some of those situations, you could have a percentage of 25%. Similarly, 10% shares, if you hold in a company, it gives you certain rights, prominently oppression, mismanagement, sort of blocking resolutions. Commercially, you have more chances of getting an affirmative vote right if you hold more than 10%. You could veto certain transactions. So these kind of minority thresholds are also critical. They are not legally compulsory. The only legal compulsion is that there are certain decisions which require special majority, which are not actually only majority, which is 51%. They are special majority, where 2/3 of the people present and vote. Bargain or leverage for various kinds of rights. 50-50 joint venture we've discussed. Controlling acquisition, 75% is again critical. For the same reason, special resolution, again for a public company, minimum public float, etc. and etc. And of course, 100% is where you make a company your wholly owned subsidiary. I hope that is clear. Should we move on? Okay, before we move on to documentation, do we have any questions on share acquisitions and the various factors that are involved?
So none as of yet. Maybe we can move on right now, and then if we get any, we can address them later.
Sure, let's do that. Now, when we are doing a share acquisition transaction, what are the key documents that you need to look at? Again, if it's an acquisition transaction by way of primary issuance, you look at a security subscription agreement, which could be a share subscription agreement. It could be an investment agreement, which details all the terms and conditions that we mentioned in our, I think, second or third slide when we were discussing transaction documents. It could be a share purchase agreement if you are buying shares of an existing shareholder. Then there's something called a shareholders agreement. This basically takes effect from the date on which the transaction closes. Now, if you have 4 shareholders in a company and they have a shareholders agreement to govern their respective rights and obligations, and you become the 5th shareholder in that company, you would also want to be bound by those rights and obligations, right? I mean, there are certain rights in the company that you would want to enjoy as a shareholder and enforce those rights against the other shareholders, because your SSA and SPA type documents are only executed with the company, not with the other shareholders. So you enter into a shareholders agreement which sets out rights and obligations of the parties in relation to the operation and management of the company. And the company is also a party to the shareholders agreement. Typically, the company, all these sort of key shareholders and your new shareholder will become party to the SHA. And whatever terms are set out in the SHA are then the relevant terms which relate to shareholder rights, operation of the company, are also incorporated into the Articles of Association, which is the first point under ancillary documents. Again, joint venture agreement, I'm not going into a full detail because it's kind of a combination of the SSA and SHA. A JV agreement will have different chapters. The first portion of the JV agreement will deal with the actual subscription or the purchase of shares. Purchase, though, it's not very common to see a purchase of shares in a JV agreement because both the entities are kind of coming together, and typically in JVs you have a new JV entity that is set up. So the first part will talk about incorporation of the JV entity and both the shareholders getting new shares in the JV entity, and the second part will flow like a shareholders agreement where it will set out all the terms and conditions on which the investment will continue to be made, any further capital commitments, right to appoint directors, any uh, deadlock related mechanism if there's dispute between the parties, etc., etc. So that's a JV agreement. Now there are certain ancillary documents, amendment of memorandum and articles of association. These are required, for example, to increase authorized share capital of the company, to include terms from the shareholders agreement which are critical. And the reason why these need to be included in the articles is, and it's a long chain, it's a long jurisprudence of judgments starting from Rangaraj to Madhusudan to sort of various judgments of various courts in India. There was this earlier section 111A which dealt with free transferability of shares of a public company. The moot point that went on for decades was whether any provision which is not set out, or whether any restriction which is not set out in the articles of association of the company, are those restrictions, are those obligations binding on the company. These are typically in relation to share transfer related obligations where you talk about preemption rights, where contractually what you've agreed is if any shareholder wants to sell its shares of the company, it needs to go to one of the existing shareholders. If that existing shareholder says no, you go to a third party. And if, for example, someone wants to not go to that existing shareholder and directly go to a third party, then you are sort of in a situation where there's a dispute, you challenge, and you basically ask the company not to honor that share transfer transaction because it's not compliant with the shareholders agreement. And then the company could claim that this is only a shareholders agreement, this is not set out in my articles, so I'm not statutorily bound by it. From a shareholders agreement perspective, it might be a contractual breach, but I can't stop this transaction from going through. So now the position is that all these kinds of restrictions need to be put in the articles of the company for it to be binding against the company and for you to have a claim against the company under the act, like basically claim like blocking that transaction, for example, or all your statutory remedies available under the Companies Act will only be available to you if you put these rights and obligations in the articles. If you don't, then all of these rights and obligations will be enforceable as a contract. And this is in the 2013 Act, it's explicitly made clear now. So that's how ancillary documents are important. Corporate authorizations, of course, these are board and shareholder resolutions. For any transaction to go through, for the company to take any investment related decision or accept any investments, uh, the board of directors must pass necessary resolutions. The shareholders must pass resolutions, as we just discussed, for private placement, etc. So all of these are corporate authorizations. Then there are ROC documents, which is, for example, the private placement offer letter, return of allotment, securities transfer form, share certificates. Then we have regulatory applications. We discussed, right, that there are certain foreign investments, there are certain sort of sectors which require government approval, RBI approval. So you'll have to obtain all those applications, draft, provide those to the regulators, answer questions, etc. And then, of course, CP documents, which we discussed, permits or approvals required from a third party, certain specific sort of consents that you want, certain specific licenses that are not mandatory under law, but you want, because this is the key part of what lawyers do in M&A transactions. We draft these transaction documents, we negotiate, we finalize these, we draft all these changes to the articles of association, we draft corporate authorizations, we prepare all these ROC filings. We don't actually prepare them because typically a company secretary does this, but we oversee, we look at what has been put in the ROC filings, we review, we provide our comments. We would also be involved in drafting and following up on regulatory applications depending on complexity, etc., depending on where our expertise lies. And of course, we draft these third-party waiver letters, third-party consent letters, and so on and so forth. We also, in fact, in the end, we also give a CP completion sort of certificate as a lawyer saying that all the CPs have been completed. All the legal CPs have been completed. So this is all very critical. Should we move on, Shrishti? Okay, now key regulatory and commercial considerations for share acquisitions. Okay, let's start right at the top. Inbound M&A. We know what an inbound M&A is, where activities where foreign investments are prohibited, sector-specific FDI limits, pricing guidelines, approvals, filings with government and the RBI. Now, again, in the previous slide, we discussed that it is critical for lawyers to have the necessary expertise, and lawyers play a key role in drafting certain documents. This slide will tell you what role lawyers play from a regulatory advising perspective on transactions. Like, some of these are only considerations. They are not documents. Most of these are actually not documents, but they are considerations, things that a lawyer needs to keep in mind while advising its client on any M&A transaction. So what do you need to keep in mind? If it's an inbound M&A, non-resident investor investing in an Indian company, you need to remember that there are certain restrictions on these investments. There are certain prohibited sectors. There are certain sectors in which only up to a particular percentage foreign investment is allowed. Like, for example, the insurance sector, only up to 74% of a company can be bought which is engaged in the insurance business. So if your client says, I want to buy 100% of an insurance company, you go back and say, hey, it's not possible for you to do that because Indian regulations don't allow that. There's this press note 3 of 2020. It's a much publicized one and giving us a lot of money as lawyers in the past couple of years, since India and China had that Galwan clash, and then following that in the pandemic, opportunistic takeovers by Chinese entities and all that. So effectively, this press note 3 of 2020, what it says is that if there's any foreign investment into India where the beneficial ownership is held by a person who is resident of a country which shares a land border with India, then all of those investments require government approval, irrespective of sector, irrespective of investment threshold. So this has now become a Pandora's box because a lot of investments that were being made into Indian companies by coming from China-based entities or Chinese firms or Chinese investors or Hong Kong or Chinese Taipei investors as well, and they're all taken into that fold. So this is another regulatory advisory piece that we do for clients where we tell them to understand and look up their ownership chain and see whether there are any Chinese or other investors based in countries which share land borders with India. If there are those investors, then what we advise the clients to do is to procure a government approval, because they're all approval route investments now, and then none of them are automatic. So you need to have sight of that. Similarly, for outbound M&A, you need to know that Indian laws have there's a piece of regulation under FEMA which is called Foreign Exchange Management, Transfer or Issue of Foreign Security, which is also called FEMA 120, which regulates Indian investors from making investments outside India. So as a lawyer, you need to know this. If an Indian client comes to you, says, I want to buy a company in the UK, you need to tell them that, okay, you can buy the company, but there are certain regulatory requirements you need to fulfill. Like, what is the total financial commitment that you can make? Because the money is going out of India, right? It's basically Indian person taking a commitment outside India. So there are certain limits placed by the Reserve Bank of India. Then what is the nature of business activity that the offshore entity can undertake? If there are any other sector specific conditions, like if you want to buy a financial sector company outside India, there's an approval requirement. So those kind of things you need to know and keep in mind and advise appropriately. Again, sector specific considerations. So how you differentiate 1 and 2 with 3 is because 1 and 2 are typically for cross-border M&A transactions. Number 3 is irrespective. Even if you have a domestic transaction, there are still certain sector specific considerations. Like if you are there are certain investment restrictions applicable for regulated sectors like telecom, pharmaceutical, banks, NBFCs. There are certain limits beyond which banks cannot invest in the shares of another company. There are certain approval requirements if you want to, for example, buy a controlling stake in a non-banking financial company. In an NBFC, if you buy a controlling stake, in fact, forget controlling stake, even if you want to change more than 1/3 of the directors of an NBFC, you need approval of the RBI. So these kind of sector specific considerations are also important for a lawyer to know and then advise the client appropriately, so that the client knows that what it wants to do commercially is also kosher under law and there are no regulatory impediments. If there are any impediments, you let them know and help them navigate through that. Similarly, one part which is an independent practice area in itself is the competition and antitrust considerations. India has this piece of legislation called the Competition Act 2002, which sets out various types of transactions which will require approval from the Competition Commission of India, the CCI. Examples could include combinations, transactions that could have an adverse impact on free competition in the market, transactions where shares are grossly undervalued, predatory pricing kind of sort of situations where entities are pricing their products so low that it's basically less than the cost price, then CCI intervenes. When in the context of M&A transactions, it could typically be two types. One is transactions which are notifiable to the CCI. Second is combinations which require approval of the CCI. So typically what happens is that, as the name suggests, Competition Act ensures that there is free and fair competition in the market and there's fair play for all players in the market, right? So if there are three major players of a product in the market and all of these three players basically compete against each other, and that ensures that the consumer is at the receiving end of the best bargain of three. If the three of them decide to form quote unquote a cartel and make a joint venture, and then basically this joint venture entity now controls 95% of the entire market share of that product, then it's something that the CCI needs to know about. That's something that this kind of a combination needs to be notified and an approval needs to be sought. Of course, it's more complicated, it's more technical than the way I'm explaining it. I'm basically dumbing this down to a level where anyone could understand this. but there are de minimis thresholds. There are certain transactions beyond below a particular value which you don't need to take to the CCI. There are certain evaluations that are made on whether the combination is likely to cause an appreciable adverse effect on competition. So depending on all of these calls, you discuss with your competition lawyers, antitrust lawyers. They will help you figure out whether you fall below the de minimis and then, of course, not require any approval, or whether you are in that bracket where you would require approval or require the transaction to be notified. Because again, something for the lawyers to know. Last, but a very important point is stamp duty and tax considerations. Typically, we have a different team looking at tax related matters. There are firms of chartered accountants. There are firms of lawyers which exclusively deal with taxation related matters in the context of a transaction. But stamp duty is typically not handled by taxation firms or taxation teams, but the M&A teams are required to be very well equipped with stamp duty implications, because in certain situations it can be huge and very denting for the transaction. It could be a very important consideration. It's an ignored one for various sort of types of documents where you will like, stamp duty, how much will you pay? 500, 1,000, 10,000. But I'll give you an interesting trivia. In Maharashtra, there is an entry in Article 5 of Schedule 1, which says that if there's any agreement that creates a monetary value, there's an agreement which creates a right, interest, or an obligation having a monetary value but not otherwise provided for in the entire schedule, then it's stamped at 0.2% of the agreement value. So just imagine if your investor wants to invest 200 crores in a company and the SPA consideration amount, the value of that agreement is 200 crores, you calculate 0.2% of that amount, and then you'll realize how critical this is to the transaction. So it's basically 20 lakhs, 40 lakhs. 40 lakhs stamp duty is very critical for the client to know. And the only way the client will come to know about this stamp duty kind of implication is when the lawyers are advising them. You need to know which state stamp act will apply, whether the Indian stamp act will apply or the state act will apply. Like, for example, transfer of shares is not stamped under the state stamp act, it is stamped under the Indian stamp act. And the reason is also very, very interesting. The reason goes back to the constitution, because the constitution schedule 7 has 3 lists, right? State list, union list, and concurrent list. So transfer of shares is put in the union list, and therefore the state does not have the power. Stamp duty on levying any form of duty, cess, charges on transferring securities, shares, scrips, etc. is in the union list. So when you are advising your client on stamping a share transfer form or paying stamp duty to the depository for transfer of demat shares, then it's under the Indian Stamp Act. So all of these are very technical things which you will get to know once you start working, once you start looking at transactions, similar things. None of these things are taught at law school. So if we have students here who are kind of listening to me, watching me, sort of, and all of this is appearing gibberish, and then you're basically rethinking what you are learning in law school, don't be surprised, because no law school across the world will teach you things about stamp duty and how critical it is for M&A transactions. You will of course read about Companies Act, you will read the intricacies of how that, you read the Tax Act as well. But all of these practical considerations you get to know only when you start working at a firm, or if you have your own setup. And when you do 3-4 transactions, you'll figure this out. So these are all practical insights that I'm giving you. So don't diss your law school for not teaching all of this. So let's move on, Shrishti. Okay, forms of M&A transactions, asset and business acquisitions. Now, this is the second form of acquiring an entity as part of M&A transactions, except that here you don't acquire entities. As you would see, these kind of acquisitions, be it asset acquisitions or business acquisitions, do not involve any share purchase or share issuance. So what exactly is acquired is the business or the assets. Let's look at it one by one. Asset acquisitions. Now, asset acquisitions do not involve sale of securities, change in constitution, or change in management of the target company. Individual assets and liabilities are itemized and acquired. Monetary values are assigned to each asset and liability, and the aggregate sale consideration is calculated on that basis. Now let's deal with one example. So I have a plant for manufacturing super high quality tennis balls. Yeah. So I would use various sort of my plant and machinery will involve various different types of equipment, certain techniques that I use to manufacture. There's a particular type of material that I use. There's a particular type of technique which I use to create that ball, which is used to play tennis. As an investor, I also have the same plant and machinery. I also manufacture tennis balls, but I am always the number 3 or number 4 player in the market while you are the number 1 player, because I have somehow not gotten hold of that exact technique that is used. And that technique is used using a machinery that you have developed. It's a different state-of-the-art machinery that you have developed. And if you use that machinery to produce that ball, it becomes, the quality is entirely different from anything else that the market produces. Yeah, I am not interested in your business because I also have the same business running for me. I have the same kinds of employees. I have the same factory workers who are skilled in how to make tennis balls. What I don't have is that one piece of the state of the art machinery. So what I will do in this situation, I will enter into an asset acquisition with you. I will enter into an asset purchase agreement where I will buy this machinery from you. I will not buy your business. I will not buy your shares. I will not take on your employees. I will not become a director in your entity. What I will do is I will transfer ownership of this asset, which is the state of the art machinery, and then all of my transaction documents, all of my diligence, etc., technical diligence, whatever it is, will only be focused on this machinery. Yeah. Now, if in addition to this machinery, I say that there are certain ancillary assets that I also need in order to run this machinery. I'll give you an example. The state of the art machinery, in order to optimize this, you need a software. Yeah. And that software is also proprietary and basically registered in your name. You have the rights to use that kind of software. So now I need that machinery, and I also need the software that helps me run that machine. So then I don't have one asset, I have 2 assets to acquire. And then, of course, my scope of the asset purchase transaction will keep on increasing depending on what assets I want. It's called cherry picking because you're effectively picking cherries. This is the entire business is the cake. You don't want the cake, you only want the cherry on the top. You just pick the cherry. You say, okay, I want this machine. How much will it cost me? It's like any other sale and purchase transaction of commodities, but it's still part of M&A transactions because the assets that form part are not tradable assets, but they are capital assets generally. If I want to buy a laptop from a company that manufactures laptops, or if I want to buy 5,000 tennis balls from this market leader tennis balls company, I'm not going to enter into an asset purchase agreement. It's going to be a regular sale in the market. But when these are capital assets, like I'm going to buy the entire machinery, for example, that you are using, it becomes an asset purchase kind of transaction. And then the focus areas are very different, and then lawyers kind of step into that domain. Yeah. Then there are business acquisitions. Business acquisitions are very similar in structure to asset acquisitions, except that in a business acquisition, there is the sale of an entire business undertaking on a going concern basis. It means that I buy a business, I lift your business, I take it and make it my own, and from tomorrow onwards, I should be able to run that business. That is what we mean when we say acquiring a business as a going concern. And it's very important that you fulfill this criteria of the business being on a going concern basis, because there are certain tax benefits that you get when you do a slump sale. Slump sale, as the name suggests, all the items, all the rights, assets, obligations, everything is slumped together into one, and that slumped business and then is then valued as a whole. Every different item is not, a value is not ascribed to every single item that constitutes that business. Like if I want to get into the business of manufacturing tennis balls, I have no plant and machinery, I have no employees, I just have a dream that I will take this business bigger, I will become world's #1 tennis ball company, and I think that I need to buy this business. Then I will buy your business as a going concern on a slump sale basis. I will not be like, your machinery costs me 100 rupees, your software costs me 300 rupees. I can do this to arrive at the final consideration, and that is exactly how businesses are going to be valued eventually. You put a value to the business, you don't say the value of the business is derived in the following manner: item 1 value this, item 2 value this. You say that the entire business is valued at rupees X and I want to buy that. I mean, it's again a very complicated tax kind of calculation, but what you need to understand is where there is no cherry picking of assets, where the entire business is sold as a whole on a going concern basis, it's called a business acquisition. It does not mean that if the company has 3 lines of business, I have to buy all 3. I could buy only one, but I'm buying a business which is independently capable of being performed from tomorrow. Like if I have 3 businesses, if a company has 3 businesses, but they are so closely interlinked to each other that unless you buy all 3, you can't perform any one of them independently, then I can't do a business acquisition of one business. I have to then buy all 3 in order for it to qualify as a business acquisition. Yeah, are you getting the difference? A business acquisition is an acquisition of a business on a going concern basis, which is independently capable of being performed using the assets and liabilities that have been acquired. Yeah. So let's move on, Shrishti. We'll take questions in the end now because we're kind of slightly running out of time because I have a lot to cover. Yeah, again, so I think some of this we've already covered. Asset purchase agreement or business purchase agreement. See, this slide is going to be simple for you because we've already dealt with most of this in the previous ones. Because in the transaction documents, the name could be different, considerations are slightly different, but it's the same kind of transaction. You know, you enter into an agreement which sets out the value, the terms and conditions of the sale, conditions precedent, closing mechanics, post closing, etc., etc. The difference, where's the difference now? Certain assets or business acquisitions will have ancillary agreements. You know, like if you want to transfer an intellectual property or if you want to transfer proprietary rights to a software, you will have to do a separate IP assignment agreement. There are certain business contracts that you might want to novate because if those business, so if company A has a business contract with a customer which buys 20% of that company's goods, and I have got that business now, this contract has no value, right? Because this contract is with a company which will not perform this business from tomorrow. So then I want these contracts as well. And that is part of my business acquisition. Then what I will do is that this existing company, which is selling the business, will go to the third party or the customer, the supplier, and will basically say that, hey, I'm transferring this business to Mr. X. Do you want to enter into a contract with Mr. X? Please do that. So that is what we mean by novation of existing business contracts and lending contracts. Conveyance of interest in immovable properties. If I want to buy a factory and that factory's ownership along with the ownership of the underlying land is with the selling entity, of course, there has to be a conveyance of that land and property as well. Of course, tangible movable assets also move across, plant and machinery. Certain things can move across by way of delivery of possession. This you will know in Transfer of Property Act, read with Sale of Goods Act, that certain kinds of properties are transferred by delivery of possession and certain have to be transferred by way of a registered contract. Now, documents required for transfer of employees. See, one interesting point is that in India, the way we work is employees are not assets because they are humans. So employees cannot be quote unquote transferred by way of a contract between seller and the buyer. So this is basically slave trade, right? Where the seller says, you know, this is human trafficking. This is, I sell Pratika Shankar for 20 rupees and now you own him. From tomorrow he will work for you.
So it doesn't work like that, fortunately, in our country or anywhere else in the civilized nations. So the way this works is there is a broad arrangement saying that because I will not do this business from tomorrow, I have no business with these employees. And because you have to buy this business on a going concern basis, you definitely need these employees from tomorrow. So the way the employee transfer kind of works is that you get the employees to resign or terminate their existing contracts, and then the purchaser gives a new offer and acceptance kind of letter to the employees. All of those who want to transfer, they will transfer. And if the employees don't want to transfer, it will be their choice not to transfer. Certain employees may be comfortable working for a particular organization, but may not be comfortable working for the other organization. So they will be non-transferring employees. There will be majority transferring employees on some employees which don't transfer. So again, these are considerations, legal considerations that you need to have a hold on and be able to explain to your client. Finally, corporate authorizations, as we have discussed before, you have resolution. Again, shareholders resolution will be required if you are disposing of the entire or the whole or substantially the whole part of your business. So those kind of considerations will also have to be kept in mind. Should we move on, Shrishti? Okay, considerations are what? Licenses and permits. Purchaser needs to procure all necessary licenses required to carry on the target business. Now, again, these are diligence points. If you are not buying the entity, if you're only buying the business, what you need to ensure is that the business needs to have all the relevant licenses and permits that are required, right? If your entity has a factory and it has 100 employees working in the factory manufacturing stuff day in, day night, day in, day out, and they don't have a Factories Act license, they don't have a license to work a factory. And of course, it's a deal breaker, right? You say, boss, you go ahead and get your license under the Factories Act, because without that, you cannot operate a factory in India. So this deal is not going to happen until you do that. It's a condition precedent to the transaction identified in a diligence exercise. Similarly, cross-border business acquisitions. If an Indian entity wants to acquire not a company but a business outside India, factory outside India, or a foreign entity wants to buy a business based in India but not actually the shares of that Indian company, you need to explain to them how it needs to be structured, because it's not that easy. A foreign entity cannot buy immovable property and factories just like that in India. They need to set up a different entity and use that Indian entity to basically acquire these properties and then own that Indian entity. Yeah, so these considerations you need to explain to them, to your client. Third party consents, you need to explain, you need to identify what consents may be required from lenders, other counterparties, because I might be buying a business where a major supplier of that business ka raw materials has put in a condition in the contract saying that the moment you transfer this, that you are not allowed to transfer this business without my approval. If you do that, I will immediately terminate. So as a buyer, of course, this contract will be terminated. I will do a new contract with him. It will be a novation anyway. But this kind of a clause in a supplier's contract signifies that the supplier is sensitive to who it is doing business with. If the supplier wants to only deal with A, B, and C type of companies and not a D type of company, and that supplier is so critical to your business that if that supplier refuses tomorrow, you will be in a soup, then you need to know this as a buyer, that hey, this supplier I may need to take approval of this supplier for this business purchase. Otherwise, this supplier will terminate its arrangement and it will go away, and I will not have a new supplier. I'll be left high and dry. Yeah. So again, these are things that you need to explain to your clients. You need to understand. Again, competition, antitrust considerations we've discussed. Stamp duty and tax considerations also we've discussed. So I can move from here, Shrishti. Okay, these are corporate reorganizations. Typically, corporate reorganizations, uh, there are various names, hive off, spin off, but typically it's categorized into mergers and amalgamations and demergers. Now, as I mentioned to you, mergers merger as per Income Tax Act is an amalgamation of two or more companies into one entity. It's a code-driven process. We've discussed mergers, right? Now we are trying to understand how mergers are implemented in the form of M&A transactions. Now they are code-driven processes where you need to form a scheme of merger, prepare it in accordance with the Companies Act. The Companies Act has detailed sections on how and what these schemes need to contain, what are the rules around it, what disclosures need to be made, what approvals need to be taken, and then you present this scheme to the National Company Law Tribunal, which is mandated under the Companies Act to approve schemes of mergers or other schemes of arrangement, compromise between creditors, etc. And it's a time consuming process, usually would take anywhere between 12 to 18 months, because you're basically not only acquiring shares or acquiring a piece of business, you are merging two different entities. You have to reconcile balance sheets, you have to reconcile rights, obligations, liabilities, you have to go to every shareholder, you have to then basically also, as part of the merger process, give opportunity to dissenting shareholders to exit. You need to buy them out. The court will have hearings. They will need to be satisfied on why this merger is required, what synergies you will achieve, whether this merger is not being objected by a regulatory authority, whether creditors are on board, whether major counterparties are, whether there are no contractual, whether there are any contractual claims pending against the parties, so on and so forth. So basically, this is a time-consuming process, takes 12 to 18 months typically. But there are also fast track mergers for small companies provided under the Companies Act. So that's also something that could take a lesser amount of time and lesser compliances, but for very different category of companies. And there are cross-border mergers where when an Indian company wants to merge with a company outside India, there are different rules around it. So the broad takeaway from here, and I think let's do demergers also and then discuss the broad takeaway. So demergers, interestingly, it and quite, it's a common sense kind of a term. So merger is when two companies merge with each other. Demerger is where one business separates from an existing company and becomes a different company. And I will tell you how it's important. Like I just mentioned to you that if a foreign investor wants to buy a business in India, it can't just buy a business. It needs to incorporate a new entity, buy shares of that entity, and then acquire that business through that entity, right? So if a target company wants to sell only one piece of business undertaking to an investor who is not a domestic investor, and a foreign investor who can't just buy the business and the factory, you can't do a sale deed and transfer the ownership to a foreign investor. What I will do is I will demerge that one piece of business out of my company and set it up as a new company, and then sell the shares of that new company to the non-resident shareholder. So again, as like mergers, demergers, hive-offs of one or more businesses of a company are also court-approved processes and procedurally very similar to a merger. It's a preferred mode of business acquisition where the target business is housed in a company with multiple businesses, and the purchaser wishes to structure the transaction as a share sale. This is exactly what I told you, right? That if I want, sorry, one other situation, if I don't want to structure a transaction as a business acquisition, I'm like, I don't want to take the hassle of acquiring a business undertaking, then doing contracts in my own name. I want to keep businesses separate. I mean, I just want to buy an entity which has this one business. And as a shareholder, I will stay on board, but this company will perform this business going forward. So in that situation, a demerger is always preferred, right? Because you will demerge into a new entity and that entity can be bought by a shareholder. So the key takeaway is that mergers, demergers, hive-offs, etc., being court-driven processes, are typically not looked at by the general corporate M&A practices in the team, in the firm, but they are typically handled by the corporate litigation practice. Because while there are corporate elements to these schemes, corporate elements in the form of Companies Act compliances, etc., the most important part of these transactions being mergers, demergers, is what happens in the court. So typically the litigation teams along with the M&A teams work on these kind of transactions and then they take it forward. With So I think this is pretty much kind of what I could summarize in 2 hours about M&A transactions, and it says nuances beyond theory. So the theory is all that is mentioned in the Companies Act, in the SEBI regulations, the RBI regulations, foreign direct investment policy in India, FEMA non-debt instruments, FEMA 20 ODI regulations. But what I just discussed with you in the past 2 hours is how we implement transactions on a day-to-day basis. We know the law, we know the regulations, but if you see there are 13 slides, only 2 slides are regulatory considerations. Because it's understood that you will know these regulatory considerations and it's part of what we do. We advise the clients. When we do a scope of work email for a client, we set out to negotiate and help with. And towards the end, we put a sentence which says, generally assisting on the Indian legal and regulatory matters arising out of in the context of the transaction. So that last part is where your theoretical legal knowledge becomes important to explain to your client all the regulatory considerations, legal implications, approval requirements, etc., the process points, how to do a private placement, how to do a share transfer, what documents need to be submitted, how does the board approve these transfers, how does the board of the shareholders approve a private placement. This is all theory. A practical implication, the practical part of it is what you draft. You need to draft representations and warranties in such a form where you are able to protect your client the best possible. Client is buying shares from an existing shareholder, warranties to then warrant to the investor that it has ownership to the shares. It has acquired the shares duly from a different shareholder. And if there is any breach of that warranty or a represent remedy in damages, the topic of a sort of work to define this work. I know reps and warranties are a part of this, of what you want to understand in this workshop. But I think in the context of a broad M&A transaction, representations and warranties are those statements of facts, as we discussed, on the basis of which a client invests in your business, on the basis of which a client enters into transaction. It could be business representations it presents about your ownership of shares. It could be representations and pending litigation matters, pending claims, or it could be certain financial representations. But you need to tell certain things about your company in order for the investor to take a informed decision. And the most amount of negotiation that the lawyers do on transaction documents is on reps and warranties. What reps are required? As a seller's counsel, you will be like, no, these reps are not mandatory. This is too wide. I want to narrow this down. As an investor's counsel, you will be like, no, this is very critical for me. Certain situations, the seller will be like, no, but I've disclosed certain things which go against this rep. So you'll be like, okay, you give me a disclosure letter against every warranty, you disclose something and say that this warranty is correct, except that I'm disclosing. I say litigation that I have done to you. A lot of things go into buckets and critique through that. At the end, when agreement, you will reach out to the responders and ask, okay, boss, I need to now make a package of what I can accept, what I can't accept. You tell me 5 critical reps that I should not accept and 5 other non-critical ones where I should go back and say I'm ready to accept deletion. So those kind of things are where you are involved. Now, what I'll do is I'll take 5 to 10 more minutes because I think we started 10 minutes late as well. Let's do, because it's a workshop, let's do some practical. So let's delve into the practical details of how it's done. Let's look at a case study. This case study is called Project Rubber. There's a target entity called Rubber King Polymers Private Limited, RPP, which is engaged in the business of processing natural rubber and manufacturing rubber sheets. Other material for making various and other industries RPP operated in distribution. Mr. Mosing and Pratika Singh, who are both Indian residents, jointly of RPP. Company which manufactures rubber products as a unit has both Indian shareholders. Your client is an investor called Predator Limited. It's a conglomerate based in and a world leading producer of rubber products. Does it ring a bell? Strategic investment, yeah, market extension. Now, Predator Limited wishes to expand its business footprint into India. And for this purpose, it is exploring a potential business opportunity with RPP. Yeah. So now, as a lawyer, what you need to do? Let's go to the next slide, please, Shrishti. So now what has happened is Predator Limited has reached out to you for advising on the following structuring options. One, acquisition of a majority equity ownership in RPP. Two, acquisition of RPP's rubber sheets business only, but not its slippers business, without acquiring any ownership in RPP. And three, acquisition of certain assets belonging to the rubber sheets business of RPP without acquiring any ownership. And these assets will include a rubber processing machine. We've discussed this, right? How asset acquisitions work. This will be a rubber processing machine and some indigenous cost-effective techniques developed by RPP for processing natural rubber into finished sheets. Kindly advise Predator Limited on the deal structure, transaction documents, and key considerations for each of the above options. Now, Shrishti, because it's a workshop, do you have any follow-on kind of activity for all the participants where they kind of answer questions or give something in writing which is then evaluated by the team?
Yes, so we'll be sending an assessment to all the participants and they would be filling out the assessment and submitting it back.
Okay, so if that makes sense, I think perhaps you can use this case study for your assessment purposes. Yeah, we can discuss this offline, but this is for all the participants here. So I think what we will want to understand is, the target and its business, the investor who is advising, who you are advising, all the three structuring options on the table. And all of these three options relate to what we have discussed in the past 2 hours in terms of how deals are structured, what documents are executed, and what regulatory considerations you need to keep in mind. Now, on that basis, why don't we try and understand, on each option, what would be A, your key transaction documents, and B, key regulatory and legal considerations that you'll have to keep in mind. Yeah. And then based on that, we'll see how the assessment goes. So what I'll do now is for the next 5 or 7 minutes, I think, let me leave the floor open for you for any questions that we have, and I'll try to handle all of those questions now. If I'm unable to do that, I think the team can still reach out to me, and then we'll of course have a different sort of question answer format if required to answer some of the other questions. Thank you very much for your time. I hope you've learned something. I hope there are takeaways, and I'm always available if you want any kind of guidance on any practical or legal sort of issues based on whatever we've discussed till now. Questions, Shrishti?
So the first question we have is that, is there a difference in the M&A process when the companies involved are public sector undertakings or government companies?
Yeah, there is definitely a difference in processes. Like if you want to acquire shares in a government entity, legally the process remains the same. But procedurally, and in fact, we are right now involved in transactions where government players are involved. It's a much more kind of complex process than it would be for a private entity, because to put it very bluntly, the systems and processes are more hierarchical in nature. So, every single discussion that you do has to go through a particular channel, and it takes much, much longer for them to deliberate over certain things, take decisions which are kind of in any way going beyond what is written in the agreement, etc. So those are all commercial implications. From a legal perspective, See, it depends on what type of transaction it is. For example, if you want to acquire a stake in an entity which has an existing concession from the government, like an airport company, for example, or a road manufacturing, or a road building company or a toll company, then the government, because it has given an existing concession to the entity, there are certain terms and conditions that governments impose on that entity, change of conditions, which will include approval of the government if you're bringing certain people on the cap table. So you need to take into consideration all that. But from a structuring of the transaction perspective, it would not make that much of a difference.
The next question we have is that, is the current Reliance Future retail deal a kind of asset acquisition?
Sorry, can you please come again?
Is the current Reliance Future retail deal a kind of asset acquisition?
So I will need to understand the broad contours of that deal before commenting whether it's an asset acquisition. I've read about it in the press, but not enough to kind of give a value judgment on it. So I'll reserve this for later. Thank you.
Another question is that, would all the IP rights also be transferred in an asset purchase transaction?
So it depends, right? I mean, it depends on what assets you want to acquire. I'll give you an example. So as I mentioned, there's a state-of-the-art machinery for manufacturing tennis balls, which I want to buy from you. I will do an asset purchase, but you also have a software. I will buy the software as well. Now, how does IP play a role in this asset purchase transaction? That state-of-the-art machine may be something over which you have a product patent. Yeah. The technique that machine uses to prepare the tennis balls or manufacture the tennis balls may have a process patent attached to it. The software that you use, which runs the machine, may also have an intellectual property attached to it in the form of a trademark, for example, or the domain name may have been or the software itself may have been protected in the form of an intellectual property. So if the asset purchase transaction which this thing become asset, but other is critical. So Shrishti, I
You're not
hello.
audible, sir. Yes, sir. Now you're audible.
Okay.
So your
Did
voice
everyone
was.
get that answer?
Am I audible to you, sir?
Yeah, you're audible. But did you get that answer? The question,
No,
was
sir,
I
your
audible?
voice was breaking. Your voice was breaking a lot.
Okay, so the short answer to that question is that if you have an asset purchase transaction where the relevant asset that you are acquiring is backed by an IP registration, like for example, a product patent over a machine that you want to acquire, or a trademark over an asset that you want to acquire, then IP becomes very critical because unless you have that product patent transferred in your name, you can't use that machine. For example, other people will also start making that machine. So then IP becomes critical where you are acquiring assets which have IP registrations on them, and where IP is very important for your business and to ensure that you have that edge over the market in that business. But otherwise, in general transactions, business acquisitions will have more focus on the IP, and asset acquisitions will have a slightly lesser focus.
The next question is that, if acquisitions are to be done through the SPAC route in India, what major regulations need to be kept in mind?
So SPAC, just to clarify, I think this is a kind of beyond the scope of this discussion, but SPACs are not legal entities. I mean, as in, there's no, so, okay, I'll rephrase. They are, of course, legal entities, but SPACs are not a different class of companies that the Companies Act sort of recognizes, or different sets of rules and regulations that apply to SPACs. They are treated as any other company from a lawyer's perspective. And I repeat myself, from a lawyer's perspective, when you structure a transaction, special purpose acquisition companies are also same as any other company. There are certain tax related benefits, tax related advantages and structuring options that you get for SPACs versus normal companies. So of course, tax is not my domain. No, I will not go into that. The short answer to the question is, you use a PAC, you use a private, the process described, the considerations I've just described will all remain the same.
I think we've covered all the questions, sir. This
Oh,
brings
great,
us
lovely.
This brings us to the end of today's workshop. On behalf of the entire board of RGNUL Financial and Mercantile Law Review, I would like to thank you again for taking out your valuable time from your busy schedule and conducting such an informative session. Your valuable insights and extensive knowledge were very enlightening, and I'm sure everyone gathered and understood a lot about the practical aspects of M&A transactions. The editorial board of RFMLR also extends our thanks to all the participants for making the session very interactive and fruitful. Finally, an important announcement for all the participants of the workshop. We shall be sending you an assignment for your assessment at 12 noon tomorrow, and everyone would be given 4 hours to complete this assignment. Thereby, the deadline for submitting the assignment is 4 p.m. And it is only upon the completion of this assignment that you would be getting a certificate for this workshop. Once again, thank you everyone for attending the workshop. Have a great day.
Thank you all very much. Have a good rest of the, have a good weekend.